state action is a concept that you'll learn as well, but because in next year. But let's talk about it very briefly. If the language is Congress shall make no law, and if we have extended the protections of the First Amendment to reach state and local governments, notice who is restrained by the First Amendment. It's the government. Okay, so when you're looking to see if there's a violation of the First Amendment, make sure that you're dealing with some sort of governmental actor. If I had a job at Progressive Insurance, a private insurance company, and I wanted to put up in my cubicle a poster of Che Guevara, the famous Cuban revolutionary, I could have my supervisor come to me and say, you know, if you'd like a picture of Flo, you can have her, but we prefer not to have communist guerrillas, you know, here inside the insurance company. Well, of course, my First Amendment rights are being violated, right? No, Progressive Insurance is a private entity. It's not a governmental actor, and so any effort by my employer to restrict my speech, at least when I'm at work, absolutely does not implicate the First Amendment at all. So remember the state action requirement. You've got to, for any First Amendment violation, you have to be able to trace the restriction on speech to some sort of governmental actor. Now, a public school is certainly a governmental actor, and so bear that in mind. All right, now, this may be astonishing to you, but I will explain it. Under the First Amendment, the government has no power to pick and choose the viewpoint expressed. The government's not allowed to say, well, that's a bad viewpoint, so we're going to censor that. Or this is a good viewpoint, so this one's okay. The government, under the First Amendment, under current First Amendment law, has absolutely no power to pick and choose which viewpoints may be expressed. Now, why is that? Well, it's because historically our government has behaved badly when given the power to restrain viewpoints. So we can go all the way back, starting with the Sedition Act of 1798. Now, didn't you just read that Congress shall make no law abridging the freedom of speech? Well, 7 years after ratifying the First Amendment, Congress enacted the Sedition Act of 1798, which made it a crime to criticize the president or Congress, which would mean that someone like Stephen Colbert would probably be on death row right now. So imagine a law that criminalized criticizing the president or Congress. Well, Congress enacted that law, and the federal courts upheld it. So we didn't have a very vibrant protection for free speech at the start, and it didn't get any better. If you look at some of the speech restrictions in the South before the Civil War, they are ferocious in their punishments of any anti-slavery speech. Any statement that criticized or even questioned the ownership rights of slave owners, listen to these penalties. In 1849 in Virginia, a statement like that, even uttered in a private conversation, would result in a $500 fine and 1 year in jail. In North Carolina, the same crime would result in a whipping and 1 year in jail. If you committed that crime again, a second time, death. In Louisiana, that same crime would result in a penalty ranging anywhere from, this was sort of the lenient side, 21 years hard labor to death. So these were the punishments for expressing the wrong viewpoint about slavery. Right? Again, why do we now forbid the government from picking and choosing which viewpoints may be expressed? because we have these lovely historical examples. How about punishing women who sought the vote? Remember, women didn't get the vote until the year 1920 with the ratification of the 19th Amendment. Well, in the year 1917 alone, 500 women were arrested in Washington, D.C. for protesting in support of their right to vote. And in fact, based on my research, I think that these women, I guess they call them suffragettes in England, and we have a slightly different term in our forget the exact term, but they call them suffragettes in England, and I can't remember the exact term we used in the United States, but they were the first to use the White House as the backdrop for their protest. You know how you see people protesting in front of that fence with the White House in the background? The first people to do that, so far as I can tell, were these suffragettes back in, starting as early as 1915. Police put up with it for a while, not long, and then they began arresting them. And then things got worse. A number of these women were savagely beaten by American soldiers and sailors with DC police looking on. And ultimately the leaders of this movement were placed in jail, and then when they went on a hunger strike, they were force-fed. And this was kept a secret from the press until the press found out. And once it was published, the women were released. But the fight for the vote was brutal, and it involved terrific retaliation against this outrageous viewpoint that women should be able to vote. Early feminists also around the same time were pushing for the publication of reliable information about birth control. That was the other thing that early feminists sought to do, and they were routinely sent to jail just for trying to publish or distribute accurate information about birth control. More recently, well, right around the same time actually, 1917, 18, 19, the federal government retaliated against people who opposed our intervention in World War I. And this was serious stuff. They were sent to jail for, well, take Eugene Debs, for example. He was a socialist leader who was one of the leading figures opposing our involvement in World War I. He was given a 10-year jail sentence for delivering a speech in Canton, Ohio, which was mild by today's standards, in which he told draft-age men, "You are fit for something better than cannon fodder." FBI agents, or this was sort of an earlier version of the FBI, but federal investigators were standing in the crowd taking notes of what he said. He was criminally prosecuted, convicted at the old courthouse here in Cleveland, and the case goes to the U.S. Supreme Court, and in United States versus Debs, the Supreme Court upheld his 10-year jail sentence. He wasn't alone. Nearly 2,000 individuals were criminally prosecuted and given jail sentences ranging from 10 to 20 years for voicing opposition to our involvement in World War I. So this is the history of the government having the power to pick and choose which viewpoints are permissible. And what the Supreme Court did in the middle of the 20th century and continuing forward is to take that power away. So now we have to put up with a lot of speech that we don't like, but it's the answer to giving the government the power to do these kinds of things. All right, now normally when the government engages in content-based speech restrictions, the courts will analyze that under strict scrutiny, which, as you will learn next year in constitutional law, is a very difficult standard to satisfy. Under the First Amendment, this is the strict scrutiny test. The regulation must be necessary and narrowly drawn to serve a compelling governmental interest. 99% of the time, when this strict scrutiny standard is applied, the government loses. I know of only one judicial decision in the last 100 years involving the First Amendment where the court purported to apply strict scrutiny and upheld the law. But it was a very unusual law involving restrictions on the ability to intimidate voters on election day near polling places. And there is some question as to whether all of the justices really did apply strict scrutiny, but the law survived. It's a case called Burson versus Freeman. It's the aberration. All right, now, before you apply strict scrutiny to a content-based restriction, you should check to see if the statement falls into a recognized category of low-level speech. And here are the low-level speech categories. There are 8 of them. 5 of them reflect, and this is all content. So this is situations where the government is allowed to engage in content-based restrictions, not viewpoint, content. O'Neill, what's the difference? Well, let me take a simple example from, let's say that Cleveland City Council enacts an ordinance that says no one shall comment on Mayor Jackson's performance in office. That is a content-based restriction. It takes a topic or subject matter and regulates it according to the content of the person's speech. Worse than a content-based restriction is a viewpoint-based restriction, and that would be something like this. No one shall criticize Mayor Jackson's performance in office. So here, worse than a content-based restriction, a viewpoint restriction is one where the government takes sides, where the government basically says, you're allowed to praise Mayor Jackson, but you're not allowed to criticize him. And of course, as we've seen, viewpoint restrictions are completely impermissible and presumptively unconstitutional. Now, there are certain areas where the government is allowed to engage in content-based restrictions, and that's with regard to these low-level speech categories. There are 5 of them on the left-hand side of the screen that are completely unprotected. So, for example, obscenity and child pornography. If speech falls within the definition of those categories of speech, the government is perfectly free to ban it, censor it, even criminalize it. Likewise, same thing for fighting words, true threats, and the advocacy of imminent lawless action. Now, there's also 3 other categories where the government is allowed to regulate based on content, but these enjoy some protection. Defamatory statements, libel and slander, commercial speech, which is the regulation of advertising, and my personal favorite, the lewd, profane, and indecent. I'm just kidding. The lewd and indecent refers to sexually explicit speech that falls short of being obscene. Profane is swear words. And so the government is allowed to regulate those things depending upon the context. I don't think you're going to run into any of these unprotected speech categories, but you are going to run smack dab into something that is called the restricted environments doctrine in First Amendment law. There are 3 settings where the denizens, the people who live in these settings, have less than full First Amendment rights, and they are prisoners, members of the military, and you'll enjoy seeing this lumped together, and students in public high schools and junior high schools. Well, they're sort of like prisoners, aren't they? But again, that's public high school. So when we talk about public high school or junior high school students, they do not enjoy the same robust protection for free speech that the rest of us do in the outside world. Now, the Supreme Court has, over time, issued 4 very significant decisions, and I think it's what people in the school law arena do is that they kind of view student speech law as occupying four different quadrants. And there are times when there will be a fight over which of these four quadrants your fact pattern falls into. But, and sometimes there is a little bit of overlap. But generally speaking, what people try to do is to figure out which of these four quadrants has the strongest claim to their fact pattern. And the law in each of these four quadrants is quite different. So if we begin in the upper left, so just, well, I shouldn't be walking around. So you can see that generally, and more recently, it is the principal quadrant that is used for governing student speech on the internet, especially student speech that, where people are engaged in social media or creating websites. Then you have school-sponsored speech. That's the decision that governs student speech that takes place in the context of some official or activity. And there's a much more deferential standard there. The Tinker standard is far and away the most speech protective standard. The other three areas are very deferential to school administrators. The Hazelwood standard is a kind of rational basis review test, and Bethel and Morse, well, I'll talk about them now. So Bethel deals with lewd or vulgar speech, and there school administrators have great power to punish speech that falls into that category. And then finally there's Morse versus Frederick, which is very narrow and deals with situations in which students are advocating or celebrating illegal drug use. God forbid. All right, so let's go through these now, starting with Tinker, which is the oldest and also by far the most protective standard. So in Tinker, the court held that school officials violated the First Amendment rights of students by banning them from wearing and then suspending them for wearing black armbands as a symbol of opposition to the Vietnam War. The court held that a student's individual political expression may only be censored or punished by school authorities if it, quote, materially and substantially disrupts the work and discipline of the school. School lawyers call this the substantial disruption test, and it is by far the most protective standard. If you read the decision carefully, you'll see that if the student speech does not substantially disrupt the school environment, the court applies strict scrutiny to regulations that seek to punish the speech on the basis of its content. Here is Mary Beth Tinker and her brother, who wore these armbands to school and were punished for it. Mary Beth Tinker came and spoke at our school a couple of months ago, and I got to meet her, which was, for a First Amendment nerd like me, it's a pretty exciting day. Now, here's the language from the opinion, and I think this is important to remember this language, because it shows that the court, when it talks about disruption, is willing to put up with a certain level of disruption. Let me just stop here for a second. If you listen to the oral argument in this case, the school board lawyer comes in and is immediately confronted by the Supreme Court with questions about just how disruptive these armbands were. And this guy was not ready. He was not ready. And you hear him flipping through the record, trying to find instances of substantial disruption. And there are, it's embarrassing. He goes for like 30 seconds, 40 seconds, silently flipping through, looking for disruption. Well, there were a few smart remarks in the lunchroom. All right. And Thurgood Marshall cross-examines him about the extent to which he was able to come up with meaningful disruption, and he really had terrible trouble, which explains this language from the court's opinion. The district court concluded that the action of the school authorities was reasonable because it was based upon their fear of a disturbance from the wearing of the armbands. But in our system, undifferentiated fear or apprehension of disturbance is not enough to overcome the right to freedom of expression. Any departure from absolute regimentation may cause trouble. Any variation from the majority's opinion may inspire fear. Any word spoken in class, in the lunchroom, or on the campus that deviates from the views of another person may start an argument or cause a disturbance. But our Constitution says we must take this risk, and our history says that it is this sort of hazardous freedom, this kind of openness, that is the basis of our national strength and of the independence and vigor of Americans who grow up and live in this relatively permissive society. So this is give you a sense of that the court does not want the school administrators to just throw up their hands at the slightest fear of disturbance and punish a student who may have a viewpoint that is different from that of the majority. Tinker also teaches us that freedom of speech extends to nonverbal symbolic expression, like wearing an armband, or burning a flag, or burning a draft card, or I think probably kneeling. I think that the Colin Kaepernick kind of gesture very, very easily falls within that idea of symbolic expression. Symbolic expression meaning nonverbal expression in which the person behaves in a certain way as a symbol of what they believe. All right, so that's Tinker. So if your facts fall within Tinker, you're dealing with a standard that is the least deferential to the whims of school administrators. Now, if you're dealing with Hazelwood, it's a very deferential standard. So, but Hazelwood is limited to student speech that takes place in the context of an official school publication, performance, or event. Let's talk about Hazelwood. There, the court upheld a high school principal's decision to remove 2 articles from the student newspaper, a story describing 3 students' experiences with pregnancy, and a story discussing the impact of divorce on students at the school. Efforts by school authorities to edit, restrict, or censor student speech that appears in an official school publication or performance will be analyzed under a form of rational basis review. Let me just drop a footnote right there. O'Neill wants rational basis review. It is the most deferential standard in constitutional law. And usually when rational basis review is applied, the court upholds the governmental action. Now what they did was they took the traditional rational basis test and added the word pedagogical. And so it's the speech restriction will be upheld if it is, quote, reasonably related to legitimate pedagogical concerns. But the rationale for Hazelwood is that Tinker should not apply to student speech that takes place in a setting that looks like the students are representing the school, and where the student speech is representative of what the school is trying to put forth. So, official school newspaper, student concert or theatrical performance, where an outside observer would look upon the student speech and think that it bears the school's, quote, imprimatur, or stamp of approval. That's where Hazel would apply. Here is the editor of the student newspaper whose articles were suppressed. She decided to publish the paper with blank spaces where the 3 articles were going to appear. Here is the school principal who decided that the younger students, the 9th grade students, were not sufficiently mature to deal with some of the topics discussed in these articles, dealing with teenage pregnancy and with the impact of divorce on students. Okay, now we come to Bethel, which deals with lewd or vulgar speech. Bethel used to also embrace offensive speech, but the Supreme Court in Morse got rid of that idea because the court said offensive can mean anything. And school administrators are easily offended, all too easily offended. So the court wiped out that part of Bethel that extended to offensive student speech. So now Bethel only applies to lewd or vulgar speech. So student speech that is lewd or vulgar may be readily censored or punished by school authorities. It isn't even a rational basis test. It's just sort of within their discretion. If the student speech is lewd or vulgar, the school administrators can go ahead and punish. In Bethel, the court upheld disciplinary action in which a student was punished for delivering a sophomoric, sexually suggestive speech at a high school assembly. The speech, made in support of a candidate for student government, contained an elaborate sexual metaphor. Quote, Jeff Kuhlman is a man who takes his point and pounds it in. He doesn't attack things in spurts. He drives hard, pushing and pushing until finally he succeeds. Jeff is a man who will go to the very end, even the climax, for each and every one of you. For some reason, the kid got in trouble for that. All right, here he is. You want to see him? Of course he looks like that. So there's your new hero, Jeff. Oh, no, not Jeff. And then finally, and these are wonderful facts, a case called Morse versus Frederick. This is the, have you guys heard of this case? This is the Bong Hits for Jesus case. I mean, this is so, brings me back to my high school days. I would have been one of these kids. All right, so here's the deal. This is really important. The Olympic torch is, I guess for the Winter Olympics, is traveling through Anchorage, Alaska. And this is a big deal in Anchorage. And so there's live television. And you have this live TV shot that is, the camera's mounted on a vehicle. And so it's following the movement of the Olympic torch. And these kids find out that it's going to go right by their high school. And so they start thinking, okay, so what do we want to do? And they're allowed to be outside as the Olympic torch goes by. So they put together this rather substantial banner that says, Born is for Jesus. So as the camera goes by, you know, it captures these kids. And of course, the school authorities are angry about this, and they want to punish these kids. The ringleader submitted to a deposition, which would have been really fun to attend. And they asked him, so what were you thinking with Bong Hits for Jesus? And he said, well, we wanted to get bong hits in there, but we also didn't want to get punished, so we thought we'll get Jesus in there too. And that might help kind of balance the two, so we would avoid punishment. Well, to me, that kid is exonerated now. It's quite anyway, so what happens is the case becomes an opportunity for political conservatives to try to take the Tinker test and just reduce it to to water it down to nothing. And so this guy, Kenneth Starr, who was also the special prosecutor in the Bill Clinton impeachment proceedings, this guy is the guy who argued the case in the U.S. Supreme Court. And what he tried to do was to water down, I think I have a slide on this. Oh yeah, here we go. In January 2007, at oral argument in the U.S. Supreme Court, Kenneth Starr tried to weaken the Tinker standard by making it easier for public school administrators to brand a student's speech as disruptive. Remember, Tinker? He argued that student speech is disruptive if it interferes with the school's, quote, educational mission. I don't know if we have time, and so I will ask Professor Micah this. I think I can make this play like the first 10 minutes of the oral argument if you want to hear the kind of reaction, because you're going to be dealing with disruption, I guess, in your problem. So I'll leave that up to you, Professor. Maybe
yeah, we probably shouldn't listen to it in class. Yeah.
Okay. So here's what I've got. See this link? It's red. Maybe you can't see it very well. So I've got a link for you guys. And so what I suggest is you click on that link and just listen to the first 10 minutes, and you'll get a sense of how the justices, Souter in particular, jumped all over him, and so he backed down. And his backup argument was that advocates or celebrates illegal drug use should be readily punishable. And so the decision winds up being extremely narrow because Starr had to backtrack from his more ambitious goal for the case, which was to basically water down substantial disruption in Tinker. So it's interesting. Okay, so just to be clear, the court upholds the suspension of a student who unfurled a 14-foot-long banner bearing the phrase "Bong hits for Jesus" while standing in front of his school with classmates and administrators as the televised procession of the Olympic torch relay passed before them. Rejecting the argument that this banner was a form of political speech protected by Tinker, the Supreme Court held that, quote, a principle may, consistent with the First Amendment, restrict student speech at a school event when that speech is reasonably viewed as promoting illegal drug use. So what happens then is that Morse is very narrow. It really is not going to apply to that many situations. So that's what you're left with then, these 4 different quadrants that make up the law of student speech. And the challenge for school lawyers or ACLU lawyers who are suing schools is to figure out which of these 4 quadrants has the strongest claim to my fact pattern. And sometimes you'll have a fight between Tinker and Hazelwood. Both will seem to have some claim. And so that's where the discussion, the analysis becomes important, because if Tinker applies, you have this heightened standard, this substantial disruption standard, whereas if Hazelwood applies, you're applying a form of rational basis review, which is very deferential. So I think that's a good place for me to stop. Well, any place is a good place for me to stop. But so I'll leave that up there, and I'm going to get out of the way. And then we can...
No, don't get out of it. You don't have to get out of the way.
Okay.
But as we talk about this, so you've read the fact pattern, and we have been kneeling at an event that may or may not be a school event.
Yeah.
Right? Yeah. And is there any way, because the disruption actually occurs more in school, is there any way that Tinker comes into the picture at all? Or is the main argument, you think, that it is a school event, and in which case, if it's a school event, then the students have a bit of a problem, and if it's not a school event, then the speech can't be restricted. So
Professor Micah, because that then that could raise. Well, this is okay. One of the things that has arisen in recent years is the ability of school administrators to reach far beyond the campus and regulate the speech activities of students on the internet, where those, so like social media or websites. So there's, in the internet cases, there's been this interesting fight over how far the reach of the school administrator can go to capture student speech that takes place off campus but has on-campus repercussions. And the courts are actually split on that.
All right.
So the internet cases may wind up having some applicability as analogs. They wouldn't be directly controlling, but they do deal with this idea of how far can the long arm of the school administrator reach beyond the campus.
Right. So it is a first-year problem.
Yeah.
And it's a motion for summary judgment as opposed to changing the law or trying to make an argument that a certain law applies. So what I have told the students and trying to reduce it to simplicity, I don't want this to be a mystery or have them, researching areas of law that are beyond the first year. No. So, and so my first thought was that the first argument is either it is or it isn't a school event.
Yeah.
Right? And that if it is a school event, then it's not that you lose. The student, even if it's a school event, the student still wins because under Tinker, we don't have the type of disruption or they can't reach and scrutinize what it is that occurred at the other event. One of those two arguments.
And I think one thing that will be pivotal is how you read Hazelwood. If you read Hazelwood and you look at its rationale, Hazelwood was meant as an exception to Tinker for student speech that arises in a setting where a reasonable observer would regard the student speech as bearing the stamp of approval of the school. And so the problem, I think, for the school board lawyer in a case like this is that when a student kneels, that's a form of protest that makes us think of Colin Kaepernick. And isn't that more an individual act than a student speaking at an assembly or performing at an official school concert or writing something in the official school newspaper? Because in the old days, there used to be something called underground newspapers. Now there's the internet. Students just jump on the internet and they express themselves there. But there used to be student newspapers in my day that were not the official school newspaper. They were made in students' basements, and they might have been distributed on campus, but they did not bear any stamp of approval of the school. And the courts uniformly analyzed those cases as governed by Tinker. They were not Hazelwood cases. So part of the problem for the school board lawyer is to argue that this is not individual expression, but is instead something that it takes place at some sort of a school-sponsored event.
Mm-hmm. I would think if I were arguing it, to me, it's easier for the school because the argument that it's a school-sponsored event and that they have every right to scrutinize the speech that occurred at the school-sponsored event. And even if you apply any type of a higher standard, then it did cause the type of disruption that most courts harder to argue, and I could be wrong, you can throw it in there.
I think there's plenty of obstacles for the student. Also, there's some, from the student's perspective, there's some bad case law out there where students have given speeches at assemblies, and there's I forget, might be a Ninth Circuit case, I can't remember, but there's a case where a student was giving a speech in support of his own candidacy for some sort of student office, and for whatever reason he used the occasion to make fun of an assistant principal, and he wound up getting punished for mocking this assistant principal. And so the argument for the student was, well, look, this is quintessential individual student expression. This is somebody who is, arguing that he should be elected to a student office. But the court said this happened at an official assembly. So I'm not going to look at the fact that the student was engaged in individual self-expression. I'm looking at the context, and the context makes me say that Hazelwood governs. And once Hazelwood governs, you got that rational basis review, which is very, very deferential to the decisions of school administrators.
Right, and from the student's perspective, I think that the first thing that has to happen is to argue that this was not a school event. Right? And what is the secondary argument? If it is a school event, then what?
Individual act? Yeah, individual expression. Very good. Very, very good.
And so we don't even get to think it if you're arguing for the student.
Oh no, I think Tinker
You do?
protects individual self-expression.
Right.
But the question is, if it's not a school event, can the government reach that far? Does the long arm of the school administrator reach that far? And that's a real question. Sam. Well, the court held that it was not a school event, it was just school. Well, again, if you look at Hazelwood turns from the idea that this is the official school newspaper. All right, remember the facts of Hazelwood. Hazelwood is a school newspaper case, and you have a principal saying, I'm not going to let these students publish these two articles, one of them about student experiences with pregnancy and the other with divorce. And this is an official school newspaper. And so, and the rationale of Hazelwood is that somebody looking at that newspaper from the outside would assume that this bears the stamp of approval of the school. It's an official school publication. Now, that's not true of a kid sitting in a classroom silently with an armband on. There's nothing official about that. That's just a kid who is opposing the Vietnam War and is going to class, not saying a word, just silently wearing an armband. So there's nothing official about that. That's just a kid going to school.
Was Tinker decided first?
Yes. And Hazelwood was decided by a more conservative court about 10 to 15 years later, and it was written as an exception to Tinker, that where the government is, where there's an official school, and so Hazelwood most readily applies to official school newspapers, official school theatrical performances like the semester play or something, right? The official school concert, like the orchestra or the band playing. That's the core of what Hazelwood applies to. It's really not meant to apply to individual student expression, like what a kid wears or And you know, like the T-shirt cases aren't analyzed under Hazelwood. It's, you know, whatever the kid wears as a T-shirt, that's individual expression. Does that make sense?
I think the easiest answer is you had two different courts. I mean, Tinker could have, the Tinker court could have been
Hand
more
that to Rehnquist.
you know.
Yeah, hand that to Rehnquist
And
yeah.
he would have made the rule that
Oh,
schools
that's right.
can censor any speech in
that's right.
school, and,
That's
and
right.
yeah, then, yeah.
That's right. The much more, I mean, I think, when's Hazelwood, 89? Let's see. As opposed to Tinker, which is right in the middle of the That's a different, very different justices. Different work.
Could you talk more about? You mentioned like it's easier. Could you mention again, like opposition to that? Like what would be or is there any bad cases?
Are there any bad cases?
I don't know. I mean, I don't know how to mention. If you're an ACLU lawyer, then you know the ones where the students lose, those are the bad cases. You know?
Yeah. Well, you mentioned it, but I didn't catch it. It was like the bad part of the school board.
Well, I guess the bad part for the school board is arguing that they have no right to scrutinize that at all. Right? Because, again, if it's a non-school event, right, what rights does a school have to scrutinize the speech of a non-school event? And, of course, from the student's perspective, that answer is going to be none. I mean, it's like school going on and seeing what you're writing on Facebook. And if you're promoting, and again, you know, schools actually do scrutinize things that students write on Facebook, but that's normally nudity and threats and bullying.
That's true. And see here,
Yeah.
I don't think you guys are going to be thinking this stuff anymore. I only read the fact pattern once, but I don't recall any lewd
No.
or vulgar speech or the celebration of.
No, but you know, if you wrote, I hate Trump on Facebook or social media, and you came into school the next day and you were suspended, I would think that one of your first arguments would be, you know, I wasn't at school. This had nothing to do with school. You can't scrutinize my speech.
Yeah.
And I think that if your first argument of this basketball tournament is that it's not a school-sponsored event, then the first argument is you can't scrutinize that speech. Now, of course, in the alternative is even if this was a school-sponsored event, your argument is you can't penalize that speech.
Right. The private payments are facts that probably cut against this being a school-sponsored event. That was one thing that kind of jumped out at me when I read the facts. Was, oh, why are these kids are making their own payments to go, and you know how's that exactly? It doesn't mean that the school can't prevail on that. But those are facts that cut against this being a school-sponsored event.
Thank you.
No, I think Professor Micah has done a great job of crafting a problem that essentially straddles the Tinker and Hazelwood boundaries. So it's very artfully done, in my opinion.
Maybe.
No,
We'll see what happens.
I mean, the reason I admire it, Professor Micah, is that in my own First Amendment class, I created about 80 problems, and that's how we learn this stuff. A lot of them are based upon actual cases, but we spend all of our time analyzing problems, you know, and that's the best way to learn this stuff is to, not just read the cases, but apply the cases to fact patterns and figure out, which case is controlling.
right. It's rare that you have any case that says, Tinker applies, this is the standard and this
Yeah,
is who wins.
like a black armband case, you know?
Doesn't work that way. They're
Yeah.
all over the place
Yeah.
with how it is that they're applying the law and
Well,
what the
that's
school
true.
can or can't do. Yeah. And it's not like, you have this graph or chart that says,
That's right.
I
yeah.
win.
Yeah, or
Uh-huh.
you are here.
Yes.
You are here. That's it.
Right.
But there's none of that.
Mhm.
The internet cases are a lot of fun. And as a teacher, it's kind of humbling because a lot of kids, like when I was a kid, if I didn't like my teacher, I would just go home and, take out a piece of notebook paper and draw a funny picture of her. And that kind of got it out of my system. But kids now, they go on the internet and they create multimedia assaults, on teachers. And then, when the school administrators find out about them, they want to kill these kids, There's one, and please pardon my language, but there's one that takes an algebra teacher. Of course, there's a likely subject right there. But this kid takes his algebra teacher and uses like stop-action animation to make her look like Hitler. And there's all kinds of stuff. And then it ends. And again, pardon my language here, but we're all adults. It ends with 131 statements in a row. Fuck you, Mrs. Matthews. Boom, boom, boom. 131 of those. So the school administrator gets a hold of that and thinks, I'm going to punish this kid. I'm going to find a way to punish this kid, So the internet cases are. Wow. Yeah.
Question?
Yeah, so for Hazelwood, which, obviously I've yes, maybe not for the first time, but does Hazelwood define the extent of what school-sponsored means to the extent of the school had an opportunity to remove it? So, for example, a comment on a Facebook page. If somebody makes a comment on their own timeline, that's obviously done in the capacity. If they make a comment on the school's page, then it's essentially something the school can then moderate. Does that, if the school leaves it there, does that imply that it's sponsored by the school?
Well, now remember, Hazelwood's dealing with facts that are, it's the official school paper. So it was easy for the court to say in Hazelwood, this is an official school publication. And this was years before the internet even existed. So you'd have to look at cases, and I don't know, this may be way beyond what you guys are being asked to do, but you'd have to look at cases construing Hazelwood and applying it. But I mean, a school, an official school newspaper, I don't think we need too much discussion to know that is, that's official, that's an official school publication.
I think even in Morse, they discussed it being an official school event.
Yes, it kind of starts this is education out of the classroom.
Well, it is.
Yeah.
Because they let them.
That's right, buddy. This is education.
But they let them out of the. They said they're leaving the classroom. They let them leave the classroom, and so had it not come down in that way, that could have been direct scrutiny of speech at an out-of-class school-sponsored
Well, yeah,
event.
that's true.
Yeah. But,
and Justice Souter says, if they unroll that banner in a classroom, okay, I can see that's disruptive. But what's disruptive about something that's happening on the front sidewalk of the school that's outside of the building, what's disruptive about that? So there was a big fight about disruption.
Mm-hmm.
And of course, what Starr was trying to do in that case was to say that anything that contradicts the mission of the school is disruptive, and so that could mean even impoliteness, right? But a majority of the court shot that down, yeah.
This is kind of also in research. Should we not look at any cases that come before Tinker then? If Tinker sets those standards?
Oh yeah, I wouldn't go back before '69. The Tinker created school law. And so does that
No,
seem-
no, I definitely agree. Yeah, we don't need the history of the
Yeah,
First Amendment.
Yeah. I wouldn't go before 1969.
Mhm.
And, no reason to do that.
Any other questions? I mean,
Really interesting problem.
when we first had this discussion, you know, I think it was 100% said they wanted to represent the student. Is that still true, hearing any of this discussion? I got some, all right. Okay, anybody change their mind? Are we still have all First Amendment lawyers here?
All ACLU lawyers, that's right.
Okay. All right, I don't know if that's going to be true once you start doing your research to see, you know, the reach and whether it is. I mean, once again, there aren't any right arguments. I mean, yes, if you don't like cite Hazelwood and you don't cite some of these, I might question, you know, some of the research, but I don't have in mind a particular argument that I want to see. I want to see what it is that you are doing with the case law and how those arguments are going to go. And that's a little bit more of a mindset that you feel it, because once you feel the argument that you want to make, then you do the research to support it. And so once again, if I were the school attorney, and I would of course argue that this is a school event, and I obviously have the right to restrict the speech at the school event, but not only that, you know, I have the right to restrict this speech through my long-armed reach of, you know, the world as it exists today, because of the danger that could happen in the school if you let things on the outside cause disruption. And I probably would give examples like, well, look at what's happening on the internet, and look at the reality of what happened after this speech occurred. I, as a school official, should be able to control my school, and now in this day and age, my school is everywhere, right? It doesn't end at the end. I mean, that would be if I were the opponent in, to all of you First Amendment attorneys.
Yeah, oh, and there's cases, there's internet cases that would support you, and they're split. The cases are split, but you know, purely private speech that a kid engages in on the internet, if it has repercussions on campus, some courts will overlook the fact that it didn't happen on campus, but it had an impact on campus, and that will be enough. But all of those internet cases are decided under Tinker, though. There's only one decision that I'm aware of. It's a Pennsylvania Supreme Court case where the court even flirted with the idea that you could apply Hazelwood to student internet speech, but that's all by itself. The vast, vast majority of student internet expression cases are governed by Tinker. And so the question then becomes, where's the disruption? Is there disruption back on the campus? And sometimes there's very substantial disruption.
All right, any other questions?
I had a question, just about the history portion.
Yeah.
That I thought was like a wow.
Yeah.
The anti-slave speech, like the punishment,
Yeah.
was that for like free slaves, blacks, whites, whoever?
Oh, well, these would be, well, I don't think that that slaves were punished under this. This was like non-slaves, suggesting that the whole apparatus of slavery was illegitimate. You know, so those were the people who were getting punished.
Yeah,
I
John
don't-
Brown was arrested for
Yeah.
that. Yeah.
Yeah.
Mhm.
So it wasn't slaves that were being punished for this. It was people out in society who were not slave owners and who, you know, were looking at slavery saying, you know, this is crazy, and we need to turn our backs on it. And those people, that's who was targeted. Some of the Louisiana statute was written in such a way as to say any conversation having a tendency to stir up dissatisfaction among not just slaves but also freedmen was subject to 21 years hard labor all the way to death. That was the range of punishments. So the idea was, we're not going to allow any anti-slavery ideas to be circulated in society, and we're going to punish them with ferocious penalties. And all this stuff was, you know,
The way it was.
yeah, that's right, 1849, 1849, so before the Civil War. Yeah. It was the wrong viewpoint. Yeah, don't have the wrong view. So the lesson to the story is, don't have the wrong viewpoint, right? But now you're allowed to have the wrong viewpoint, because the Supreme Court has stepped in, and in the last 70 years has done a lot to protect such crazy viewpoints that women deserve the vote, right? Oh my God! See, well, that's the reason that I mentioned it. It's like people say, oh well, but this viewpoint, can't we all agree that that should be punished? You know, the problem with that is that most people opposed a lot of, well, for example, most people opposed any anti-World War I speech. Like, people thought, you know, if you're going to oppose, once Congress declares war, there's no more debate. That's it. We're going, and anybody who questions whether we go to war it's treason. And you're going to jail for 10 years. And so that's why we've taken away from the government the power to pick and choose which viewpoints can be expressed.
Okay, anything else?
Well, good luck. Good luck.